Ready? 3, 2, 1, start. In our considered opinion, the act of the lodging of a criminal case, getting the respondent arrested and opposing his bail are acts which amount to cruelty as has been held by this court in the cases of Shrimati Kanta Sachdeva, Johnson Joseph, Shrimati Chandan Agarwal, within bracket Supra, and therefore the conclusion as recorded by the court below is perfectly justified and does not warrant interference. Stop. Another significant fact that has come up in evidence is the false, unestablished, wild allegation by the appellant against the respondent in respect of his having an illicit relationship with one of the relatives of his sister-in-law. Stop. Wild, unsubstantiated allegations which amount to character assassination also do not support or help the cause of the appellant in the present appeal. Stop. In our considered opinion, such wild, unsubstantiated allegations which have been taken up as an afterthought also amount to cruelty and lend support to the conclusions recorded by the court below. Stop. In a case of V. Bhagat versus Mrs. D. Bhagat, where wild allegations had been made, the Supreme Court, while dealing with the issue of mental cruelty, has laid down the law in the following terms in paragraph 16 of the judgment, which may be profitably reproduced. Stop. Para. Mental cruelty in section 13 within bracket 1 can broadly be defined as that conduct which inflicts upon the other party such mental pain and suffering as would make it not possible for that party to live with the other. Stop. In other words, mental cruelty must be of such a nature that the parties cannot reasonably be expected to live together. Stop. The situation must be such that the wronged party cannot reasonably be asked to put up with such conduct and continue to live with the other party. Stop. In the facts and circumstances of the case, it is established that the conduct of the appellant has inflicted mental pain and suffering upon the respondent. Stop. As has been held by the apex court in the case of V. Bhagat versus Mrs. D. Bhagat within bracket Supra, any conduct which inflicts such mental pain and suffering on one of the parties and is of such a nature that the parties henceforth cannot possibly live together amounts to mental cruelty, and under such circumstances the wronged party cannot reasonably be asked to put up with such conduct and continue to live with the other party. Stop. In view of the above mentioned analysis, this court is of the opinion that the respondent has firmly established and proven cruelty on the part of the appellant. Stop. In view of the above mentioned analysis, we are of the considered opinion that the conclusions as recorded by the court below that the conduct of the appellant amounts to cruelty, and on that basis allowing the application was filed by the respondent does not suffer from any perversity or material irregularity which would call for interference by this court. Stop. In conclusion, the appeal filed by the appellant being meritless deserves to be and is hereby dismissed. Stop. There shall be no order as to costs. Stop. Over.